If you're like us, you're probably tired of flipping through outdated and expensive regulation books and struggling to understand the rule or guidance you're after. eRigs is the first web and mobile app version of the Federal Motor Carrier Safety Regulations, helping fleets of all types and sizes better access and understand their regulatory obligations. eRigs is always up to date and allows fleet safety professionals to not only read the rules, but also dig into FMCSA guidance and learn more about complex regulatory topics from industry experts. Highlight, bookmark, and take detailed notes right from the app and access them on any of your devices. And easily share a digital version of the regulations with your drivers so that they too can better understand the rules. eRigs was developed by safety professionals for safety professionals. Try it out for free at erigs.app. All right, hey everyone, welcome to episode 45, Trucksafe Live, show where we and our guests tackle the hot button issues impacting highway transportation. I'm Brandon, that's Jared. We are with Trucksafe, Childress Law, both of which are dedicated to helping motor carriers develop and maintain cutting-edge safety programs. Happy New Year to everybody. This is our first show in 2025. Took a couple months off there. Had some stuff going on, had a new baby in that time period. So, exciting things going on there. And then also at Trucksafe for sure. We've got a lot in store for 2025. So a lot to talk about, but glad to be back. Jared, your year's going okay so far, hopefully?
Yeah, going good so far. I didn't really have time off, as you say. I wouldn't really call having a baby time off, but my year's been uneventful compared to yours.
Yeah, you just got back from Australia, though. No?
I did, yeah. A little bit of jet lag this week, so doing pretty good.
All right. Well, that's all that matters. Let's see. I kind of forget how to do the show here, so let me try and remember how to do this. If you're here with us, watching live, say hey in the comments so we know everybody who's here. And excited about today's show. We've got a good topic to talk about, exciting news on our law firm side of things. Hired a new attorney who Jared and I have worked with for many years. So excited to have him on the show today to kind of break down some of the key legal issues that fleets need to be aware of for 2025 and beyond. So looking forward to that. Before we get to that, though, a few things going on here at Trucksafe that we should talk about. Well, first of all, let me say thanks to the sponsor of this episode, Taking the Higher Road, a Legacy Builders and Freight Waves production. Taking the Higher Road is a special podcast dedicated to addressing the trucking industry's greatest challenges, driver recruiting, retention, and compliance. Each week, host Jeremy Raymer, 20-year industry veteran and founder of Driver Reach and Legacy Builders, interviews industry experts and thought leaders who bring their insights to the driver life cycle. Be sure to check them out wherever you get your podcasts. So thanks to Taking the Higher Road. One thing that we just announced on the Trucksafe side of things that we're really excited about is our next Fleet Compliance Boot Camp. So this is our in-person conference, 2-day in-person conference that we do once a year. This is our 4th boot camp. This one is presented by DriveWise, so thanks to the DriveWise folks for sponsoring this year. It's going to be September 3rd and 4th in Indianapolis. Like I said, 2-day conference. We're going to get together with a group of around 100 or so safety professionals, safety managers, safety directors, risk advisors for insurance companies, those types of folks to talk about nothing but DOT compliance. So it's been a good thing for the last few years here. Get a lot of great feedback from it every year. Looking forward to doing it again. We've got a bigger venue this year, so we ran out of room last year at our last spot. So looking forward to that. Hopefully you are too, Jared.
I am indeed the 4th one that we've done. they're always fun events. They actually get easier and easier each time. So I'm glad that the event's growing a little bit more incrementally, not necessarily just for the amount of people coming, just because the demand for it is growing a little bit. So that's good to
Yeah.
see.
Yeah. So if you're interested in details on that or to register and join us in Indianapolis in September, check out the details over at trucksafebootcamp.com, and we hope to see you there. Next up, I'll mention the Trucksafe network. If you haven't joined the network, I really encourage you to do so. This is our network that we created for fleet safety professionals to gather together, learn from one another, ask questions, and also access all of our DOT-related content that we push out through Trucksafe, videos, webinars. We just did a long webinar series last year all about improving CSA scores that was really well attended. So all of that type of stuff is available to network members. It's free to join. You can get the details over at trucksafenetwork.com or scan that QR code there, or download the app in the App Store or the Google Play Store. Great resource for fleet safety professionals. So hope to see you there too. Lastly, I'll mention our newsletter. If you're not subscribed to our newsletter, that's a great way to stay on top of what we've got going on at Trucksafe, which is a lot more nowadays than it used to be. But trucksafe.com/subscribe is where you can get all of our breaking industry news and our analysis of it that we push out, usually kind of on a weekly basis. So if you are in a fleet safety position or a risk advisor or anything like that, and you want access to, what's going on in the industry from a compliance standpoint, that's a great way to keep on top of that stuff. So check that out. Again, trucksafe.com/subscribe. All right. Did I miss anything, Jared?
No, I think you remembered how to do that pretty well, actually.
It came back to me, came flooding back to me there. So I think we're good to go. But anyway, moving on. So as I said, topic of today's show is key legal issues for fleets in 2025. Thought this would be a good way to kick things off for the new year, at least for our show here. We ended last year, the last Trucksafe Live we did in 2024 was kind of a look back at 2024, what we saw from a regulatory standpoint, what kind of rules the FMCSA was pushing forward with, what we saw from an enforcement standpoint. But we didn't really look at it so much from like a legal standpoint. What are some of the legal challenges that fleets are facing? And so I thought that would be an interesting way to kick things off this year. So I'm excited to have with us today Tyler Biddle. Tyler, welcome to the show. Can you hear us?
Thank you.
Okay.
Yeah.
All right. Here we
happy
are.
to be on. Thanks for having me on.
Yeah,
Hey.
I thought we were going to have intro music. He requested Rock You Like a Hurricane, but that didn't happen. Sorry about that.
Yeah, sorry. We're not that technical here.
No, that's good.
But anyway, so as I mentioned, Jared and I have worked with Tyler for many, many years now, and we're excited to finally have him on board with us. We've kind of been wearing him down for the last couple of years, trying to get him to come over, and he finally broke down and did it. So we're excited to have him on board. I'm going to let you, Tyler, go ahead and introduce yourself, kind of your background, how you got into transportation, that type of stuff.
Yeah. Thanks again for having me on, and happy to be working with you guys again. So just by way of background, I started my legal career working with Brandon and Jared at my first firm, boutique transportation law firm dedicated to the transportation industry, representing transportation companies, motor carriers, freight brokers, warehousemen, freight forwarders. From there, I actually went to a much larger firm, about 700 attorneys for the past 3.5 years. Did a lot of corporate transactional work there, a lot of mergers and acquisitions, corporate restructuring. Again, a lot of that type of work. And then, after, a number of conversations with Brandon and Jared, just really I'm excited to be working with them again. Joined them at the beginning of this month, February. And it's been fun so far. And obviously, this is a really, really great opportunity to join you guys on Trucksafe Live.
So you went from medium-sized firm to large firm to tiny little law firm. This is where you're at now.
Yeah, I've really gotten the flavor of it all. Maybe who knows what's next? No, I really hope there is no more law firm jumping.
Yeah, no, we're excited to have you, and also on the Trucksafe side of things. So, forgot to mention that Tyler's going to work with us on the Trucksafe side of things. So, all the resources we've got available at Trucksafe, Tyler's going to help us push that forward. He's going to be at the boot camp, speaking at the boot camp with us. So, really looking forward to that. But Tyler, while we got you here, we thought it would be a good time to talk about some of the top legal issues. You've got a better pulse on a lot of these things than Jared and I do. On the law firm side, we tend to stick to our lane, which has been DOT safety regulations primarily, but you have kind of a broader base understanding of the legal issues impacting a lot of fleets and brokers and shippers out there. So I'm just going to turn it over to you, and maybe we can hit on maybe like the top 5 legal issues you're seeing and that fleet should be considering. So I'll turn it over.
Yeah, and I think there are some really I would say exciting for me from a legal standpoint in terms of what could happen, but there's some really kind of hot issues right now for fleets to kind of be tracking, considering. I think and some of this is really politically driven. So after, having this election, a prior administration, proposes rulemaking, or has some laws passed, and things change when you get a change of administration, and some of it will be really interesting to see how things develop in light of who's running, especially right now the FMCSA. The first thing to anybody who's following it is the proposed FMCSA's proposed rulemaking on broker transparency. This happened late last year. The FMCSA proposed some additional rules to 49 CFR 371.3, which requires brokers to provide certain records to carriers upon request. They had opened it up for comments. They had received over 3,500 comments, or no, 5,300 comments so far. The FMCSA reopened.
How many of those were from you? 5,100.
Yeah, 5,100. No, I mean, it's clearly a huge issue, and really the thing that prompted this was really OIDA wanted some transparency here, because the small fleets, especially that work with brokers, have kind of felt like they've been getting screwed in large part.
Because they don't know what kind of cut the brokers are getting off of the movements and that type of stuff.
Well, that's it, and that's some of the problem is the smaller fleets are saying, hey, these brokers, they're taking way more than they should. We're the ones actually moving the goods. What do they have into it? As if these large freight brokers have invested a lot of technology, a lot of money into developing these customers, coordinating these shipments.
Devil's advocate, what they have into it is the relationship with the shippers, which the carriers aren't going to get on their own. So
no, but some transparency. I get it, and some of this really kind of originated, and if anybody's really been following it from a real detailed perspective, there was a specific shipment, the carrier named Pink Cheetah Express. It was hauling a shipment of ice cream for Total Quality Logistics, TQL. And the owner of the company, she had requested, hey, TQL, I want the records for this shipment. And after, TQL obviously denied it, their broker carrier agreement that Pink Cheetah Express agreed to, it's got a waiver. It's got a waiver of, the carrier's right to records and 371.3. That waiver is in every single well-written, any well-drafted broker carrier agreement is going to have that waiver, right? And I think that's really the key to any rulemaking going forward. So anyways, Pink Cheetah Express didn't get the records. She filed a complaint with the FMCSA. FMCSA started communicating with TQL saying, hey, look, we don't think your waiver is valid. You're from a regulatory standpoint, you are obligated to provide these records to this carrier. And after, there was some email communications back and forth, apparently or allegedly, the FMCSA threatened to show up at TQL and get the records. So then TQL, turned the records over, and it showed that they had, a pretty high profit margin. It was like 40-some%. right? And I think that's the concern that the small fleets have is, gosh, we are getting screwed, right? We have no idea, in what these brokers are getting, and we feel like we should be getting more, right?
Yeah, I mean, makes sense, but I don't know. I always come back to this on these types of issues. It's like, why is FMCSA being dragged into this? Because in light of deregulation, I mean, that just, it bugs me to no end that we are asking the FMCSA to weigh in on what is essentially a private dispute between contracting parties. This is the
Yeah.
Federal Motor Carrier Safety Administration, whose
Mhm.
only obligations or only tasks are to improve highway safety. Why are they, and they don't even have the resources necessary to effectively do that job. But now we are having them spend some of their resources to essentially asking them to more deeply regulate the aspects of trucking that Congress expressly deregulated back in the 80s and 90s. I don't understand why we're doing that.
Yeah, I think that's going to be a big issue for the proposed broker transparency rules going forward, setting aside, deference to administrative agencies that's changed, in 2024 via, Supreme Court rulings. But hey, does the FMCSA really have the statutory authority to propose these rules? I mean, if anything, I'd have to look into it a little bit more, but the Surface Transportation Board tends to be the entity that another sub agency that sits under the DOT that deals with the economics of transportation, right? I mean, they regulate rail tariffs, they regulate household goods, antitrust issues. It may really more realistically fall under their purview, in this regulation specifically.
Here's a question for you. Somebody on YouTube's asking. By the way, any answer that Tyler gives to this is not legal advice and should not be taken as such. Aaron's asking, what type of liability does a brokerage have if they opt to create a bill of lading for their customer? Do they need documented approval of each bill of lading created on the customer's behalf?
So this is interesting. So if you go back and look at it, there's a Bill of Lading Act, and it was probably sometime in the 1930s. Actually, the motor carrier is obligated to issue a bill of lading. And you may say, well, what are you talking about? The shippers do that. All right, yeah, in practice, shippers create the bill of lading, but pursuant to federal law, it's actually incumbent upon the motor carrier to issue it. Right now, typically, right, we've got your your standard bill of lading terms and conditions. Carrier signs it. Okay, yeah, there's nothing prohibiting a broker from creating that bill of lading, right? Often, and it's not and something that they like is when they're listed as a carrier on a bill of lading.
Mm-hmm.
That's something that they try and avoid if they can. But there's nothing saying that they can't create that bill of lading. That doesn't change their liability for either payment or cargo liability. Yeah,
the one area where I could see it potentially impacting them, always kind of my mind always goes to DOT compliance, is if it's a hazmat bill of lading. The hazmat regulations are very specific in terms of the paperwork, the shipping papers applicable to hazmat shipments. And if you as a broker take on the responsibility for preparing the shipping papers that contain hazmat shipments, you take on regulatory responsibility for filling those out correctly. And if you don't fill those out correctly, then PHMSA is going to be on you potentially for screwing that up. So I would watch out for hazmat shipments in particular.
Yeah, so I mean, essentially, they're the brokers taking on a shipper responsibility for the hazmat regs, right?
Yeah, the hazmat regs, man, are dense. We think the Federal Motor Carrier Safety regulations are dense. The hazmat regulations, I do not envy any hazmat carriers out there having to comply with both rule sets, having to understand both rule sets. But yeah, I mean, there's all types of traps in the hazmat regulations like that, where if you perform a hazmat function, a pre-transportation function, then you take on regulatory responsibility for whatever function you take on as a broker or a shipper or a carrier. So yeah, something to watch out for.
Quick question from me on broker transparency, kind of in the vein of the comment that Brandon made earlier about limited resources. With these additional requirements, like requiring electronic record keeping and implementing a 48-hour timeline for record disclosure, things like that, First of all, how is this going to be policed? Is this going to be another thing unloaded on FMCSA to police? And how are brokers going to be held accountable?
That's a good question. I mean, yeah, who's going to regulate this?
Yeah.
Now, arguably, there's a private right of action that, a carrier could sue, right? But that requires some resources to do that, right? To enforce it via litigation. But yeah, I think that's a great question. Who's going to enforce this? Because I mean, shoot, the FMCSA doesn't even enforce illegal brokerage right now. I mean,
Yeah.
really, practically speaking, you want to talk about issues with illegal double brokering, carriers brokering shipments without brokerage authority. I mean, that's happening all the time and contributing to the massive amount of fraud we have. And FMCSA can't even regulate that. What they're going to regulate this? I don't see how they could do it,
Yeah.
quite frankly.
Jack Van Steenberg on LinkedIn is saying Oweida's point is that with more money carriers get from brokers, they will put towards safety. LOL. He says this regulation is left over from the old ICC days. Yeah, I agree. I mean, that was my point. Is that these are holdovers from the commercial regulations that the Interstate Commerce Commission before the FMCSA
Yeah.
used to have the authority to regulate these things, and some of those aspects of it are holdovers that are still on the books but are not enforced because the FMC that part of transportation is deregulated. So it's matters of private contract. It's the market that is to figure this out, and private lawsuits and stuff like that. So yeah, I don't know.
Well, and I think, again, this has nothing really to do at all with safety, but from a, market perspective, and if you look at most of the comments, I mean, I think most people are in agreement. Yeah, this isn't gonna make sure that it's not gonna like level the playing field or make things more fair or ensure that carriers are being paid more. If the load doesn't pay, don't take it. Right. And I think that's been
Yeah,
the
it's
problem
not
we've
like
seen.
the rule they would come out with would say you have to pay this X
No.
amount. It's just going to say you have to disclose what you're paying.
Yeah,
So
and I don't know, for any fleet, nobody's holding a gun to your head and saying you must accept that shipment,
right.
right? If it doesn't pay, don't take it. And I think we've seen a lot of that over the last couple of years, with the market being as bad it is, especially the spot market as bad as it is, people are taking loads that may not pay just to keep the wheels turning, and that's market dictated. There's a glut of capacity and not as much need. So people are taking shipments. You don't have to take that load if it doesn't pay.
So
You don't have to work with brokers that
yeah.
you don't think pay right.
So you've looked at some of the comments. I can't imagine this is very popular among the broker interest groups out there.
No, definitely not. I mean, they've most of the large freight brokerage entities have filed comments. Transportation Intermediaries Association. Of course, they, and I think their biggest problem, confidentiality. Hey, I don't want to be sharing all of my customers' name, all of that information because, quite reasonably in their own, customer facing agreements, they've got confidentiality obligations. And well, this kind of messes with that a little bit. And then the turnaround, it's as of right now, there is, we do have the regulation on the books that a broker is required to provide these records. Okay, it's on the books. That's what it is right now. These broker transparency rules are kind of, amending that to a degree. So, right now, unless there's a waiver in the agreement, hey, they've got to provide these records. I think the 48-hour turnaround is a pretty tough one, right?
Yeah.
Because quite reasonably, they may not have all those records from their customer within 48 hours. Is that an ongoing request then? Maybe all that information isn't compiled in the same place. So I think it would be pretty difficult to comply with. And assuming that waivers are not enforceable, okay, is every carrier requesting records after every shipment? I mean, that could really create a maybe an impossible administrative burden on a broker to be able to actually comply with that.
Yeah. I question whether the FMCSA has the authority to say whether something is waivable or not. Seems like a legal question up for the courts. But
yeah, it really is, and I'm glad you brought that up. So continuing the saga of Pink Cheetah Express is 2 days ago? 2 days ago, Pink Cheetah Express filed a lawsuit in the District Court of the District of Columbia. That's a federal court in DC against TQL related to this, this whole shipment and the records. And there they Pink Cheetah requested that, TQL turnover. I think it was records related to about 16 shipments, but also, and this was part of it, was the FMCSA had ordered TQL to remove the waiver language from their broker carrier agreement. Yeah.
I don't think they can do that.
And that's Pink Cheetah's asking the FMCSA or asking the court to enforce that. That gets into a really, really, and I think that gets to the heart of these whole broker transparency proposed rules is, hey, this is great. We've got some new rules. If somebody wants more transparency, okay, great. If it's something that can be waived in every agreement, it's pretty much ineffective because every broker is going to have that waiver in its agreement. There's actually a specific statute that allows shippers and carriers to waive rights and remedies. It doesn't say broker. And that's why I'd love to see the court be able to get to the merits of that. I'd be surprised if it does at some point. But hey, is that waiver effective? Because if it is, none of this really means a whole lot.
Yeah. Okay, that's broker transparency. What's the status of that? I think they just recently extended the comment period. Is that right?
Yeah, they extended the comment period a couple weeks ago, so probably have another couple weeks. If you want to add to the 5,300 plus comments, I'm sure FMCSA will read each and every one in detail. So
this is a notice of proposed rulemaking, right? So next step would be a final rule, which would establish the rule if they end up doing that. So that's what we will be on the lookout for.
Yeah. And I think I mentioned the political piece of this is, the proposed rulemaking was under an FMCSA under the Biden administration. We've had a lot of change in personnel in these agencies, including the FMCSA. They actually have a new special counsel, which is kind of the agency's attorney. So I would assume that they're looking at this and maybe even reconsidering, that's a possibility that this doesn't move forward.
Chuck on LinkedIn is saying, while you can reasonably argue whether or not FMCSA should be regulating broker contracts, the fact is that they currently do. I would disagree with that. Can both parties, they certainly regulate brokers in the sense of requiring brokers to have brokerage authority, but I would argue that they don't have authority to regulate the terms of their contracts and haven't had that authority since deregulation. But in any event, can both parties to any contract illegally waive any safety regulation? Completely different issue. No, can't be done. Any other thoughts on that?
No, I mean, the FMCSA, I agree, doesn't really regulate, broker carrier agreements or those relationships. Yeah, and I've never heard anybody being able to waive safety requirements.
That'd be nice, right?
You can contract for whatever you want, but is it going to be an enforceable contract? Yeah. And the fact that the safety regs are there doesn't mean that an individual contract can waive them away. Absolutely.
Yeah, because safety regulations are not the matter that's being contracted for, right? Whereas the brokerage terms that we're talking about, the disclosure of the payment terms, stuff like that, is directly an issue between the two parties. Safety regulations sit out there as a third-party issue, so I can't even really see that coming up. But in any event, okay, so that's broker transparency. Let's move on. What's your second top legal issue for fleets to consider in 2025?
Second, lease purchase agreements. There was a truck leasing task force. It was authorized as part of a bipartisan infrastructure bill in 2021. So this truck leasing task force created by the FMCSA, again, under the Biden administration. And it was created to investigate and assess truck lease purchase agreements. These have become a kind of a, big issue because, there's a lot of failure, right, in these lease purchase arrangements. And, frankly, the truck leasing task force was full of, I would say, plaintiff-friendly type people, right? I mean, there were a couple plaintiffs' attorneys on there. There was a director of economics from the Teamsters Union. OIDA had a seat at the table, and
Seems pretty
they
unbiased
issued
so far.
a little pretty biased. So they issued a report in January. It was January 17th of this year. They had spent some time, researching to the extent they could, various lease purchase arrangements, and then they just pretty much decided, hey, look, these are bad. They should be outlawed. They should be banned. And that was, from a high level, what their findings were. Now, what will come of that? Again, we've got a change in administration. I suspect not much will come of it. How is again, what the FMCSA, Congress, somebody's going to ban lease purchase agreements. I'd be surprised if
kind of
if this
same
moves
issue,
forward.
because what we're talking about, well, partially is, the federal truth in leasing regulations play into it somewhat. But again, another issue that is under the FMCSA's regulations, but not entirely clear why it's still under the FMCSA's regulations. Another thing that doesn't really have all that much teeth from a regulatory enforcement standpoint, but more kind of an issue between private parties and, potential private rights of action, stuff like that. But yeah, but these lease purchase agreements that we're talking about are very common, particularly for large owner-operator fleets, where they will enter into, the trucking company or an affiliate of that trucking company owns the commercial vehicle, leases it to the owner-operator. The owner-operator in turn leases it back to the motor carrier pursuant to those truth in leasing regulations to operate under the carrier's authority. But a component of those lease agreements gives has a purchase option at the expiration of the lease agreement, assuming the owner-operator meets the terms and conditions of the agreement. Is that it in a nutshell?
Yes. Yeah, that's it. And I think in the truck leasing task force's report, I mean, the focus is on kind of that lease back arrangement when, the motor carrier itself is leasing the equipment that is leased back, or an affiliate of the motor carrier, because then that owner operator is pretty much stuck. They're stuck with the truck, and the truck must be operated with that motor carrier, right?
Yeah.
Or else they're in breach of their agreement. And that's from a high level, I get that. It's like, hey, that, maybe that doesn't seem fair. Okay. But the where I've seen fleets that, operate lease purchase programs, which, I mean, those, provide the ability for people to, run and have their own, business. I've seen fleets get into trouble, and this is where they get sued, and usually it's, truth in leasing regulations claims. When that owner operator doesn't make money, right? If you're structuring it in a way that these guys aren't really making any money, like, don't be surprised when you get sued, because that's where, I mean, and look, there's good and bad actors in every industry, and this industry is no different. If you're setting somebody up for failure, that's just not right. It's not right from a business standpoint, and it's probably going to not turn out that well for you.
Yeah, the other area where I see this come up quite a bit, the legitimacy of these lease purchase programs, is in the independent contractor classification. I know that's one of the items on your list, kind of flows into it, but we used to see this all the time back when we were all at the same firm, and I was kind of in that area. State agency, work comp boards, or unemployment agencies, or the plaintiff's bar would get a hold of these lease purchase programs, the carriers that employ them, and would essentially say, that's just a sham. That is, you have set that up as a way to try and demonstrate that the owner operators have some skin in the game, that they are their own business, but this is ultimately your asset, and they are beholden to you, as you mentioned, Tyler. And so this is a sham arrangement, and so we're not treating it as a legitimate independent contractor relationship. And so now, carrier, you're responsible for work comp or unemployment or overtime or whatever context it's in. So yeah, a big issue, and something fleets that have that type of program really need to pay attention to.
Yeah, absolutely. And I think the direct leaseback arrangement is obviously kind of the worst way to do it. Hey, my entity has motor carrier authority. I've got the equipment. I'm going to lease it to my owner operator, and they're just going to lease it right back to me. At least have affiliated leasing companies
Yeah, I think
set up.
some state statutes specifically carve that type of an arrangement out from a legitimate, like an owner operator exemption in work
Yeah,
comp statutes. They will say this does not apply to leaseback arrangements. I think Oregon used
correct.
to
Off the top
have
of my
something like that.
head, off the top of my head, Illinois, I know, is one of those. And Illinois is even specific enough where, hey, look, I've got an affiliated leasing company. Let's say it's owned by my brother instead of me. I own the
Mhm.
carrier. My brother owns the affiliated leasing company that's leasing the equipment, to the owner operator who's then leasing it to me as the motor carrier. It gets into that detail that family members, that is not that doesn't meet the requirements for the exemption for unemployment tax or workers' comp for owner operators. So yeah, that's absolutely true.
Yeah, Brian on LinkedIn says companies have used lease purchase agreements to hide employee status. I don't disagree with that. I think that's probably accurate for some carriers, but certainly not all carriers. Structured correctly, I think it serves a legitimate point in the industry and can actually work to an owner operator's benefit. I don't think all of these, this is just my opinion, obviously. I don't think all of these arrangements are as the lease task force has described or as the state agencies or the plaintiffs bar make them out to be. I've personally deposed. I've personally ridden in trucks with owner operators that work for carriers, and they are in the midst of a lease purchase program, and they wouldn't have it any other way. I've talked to them directly. They love it. They love the freedom that it affords to them, and a state coming in and telling them that they are an employee rather than an independent contractor seems like a slap in the face to them. They have told me that directly, and I find that to be the case in many instances. So I just don't think it's as pervasive as this task force made it seem to be, at least from my perspective.
No, I
Yeah,
agree. I agree. Oh, go ahead, Jared.
I was going to say the task force report, which you can actually find online pretty easily and read it. They actually describe these agreements as irredeemable tools of fraud, which I thought was pretty extreme. Kind of to that point, I mean, how do you get far away from being an irredeemable tool of fraud other than just ensuring that this owner operator is able to make money under this lease purchase agreement? How do you take that even farther away from that statement in the terms of the agreement?
Yeah, I don't. They're probably looking at a very limited subset of the bad ones, right? And I'm sure that any carrier that's running a legitimate lease purchase program isn't going to didn't you know hey, here, you want to see my program, hey, federal government, you want to come in and look at my my program, my success rates, my agreements, and all of that. The data they were looking at, I'm sure, was, again, bad actors or people who don't have things set up in a way to be fair, to enable these owner operators to succeed. And they had cited various success rates in the report. But I was kind of thinking about that. Hey, all right, so you have, and when I say success rates, I mean contractors that actually
Buy the truck
participated in the
or
lease
get the truck
back and got to the end of the lease
and
and
got
purchased
title
the
to it.
agreement.
Yeah.
Yeah, right. And there could be a lot of reasons why that doesn't happen. Many reasons. One of them could be, hey, the equipment, we just didn't end up wanting that equipment, or hey, we had to quit driving for whatever reason. I mean, there could be a plethora of reasons why somebody doesn't get to the end of a lease purchase arrangement. It doesn't make sense financially, but also I was thinking about it just from a high level. How many any business, what's the success rate of a business? So let's say you're starting a restaurant. What's the success rate of a restaurant after 4 years? My
Depends
understanding,
if
pretty low.
Gordon Ramsay shows up or not.
Yeah, right. uh, but so I don't really put much weight into those success rates that the task force quotes. But again, I think it comes down to, if you're running one of these programs, you're going to have to take a close look at it, try and structure it in a way that makes sense, that you're compliant with the truth in leasing regulations, especially that you're not opening yourself up to some risk of non-payment. And then if you're structuring it in a way that the guys can't make money, it's
The,
just
the
not
one,
a
the
good
one
program.
that comes to mind is the one you mentioned, Tyler. We saw this pretty commonly. I understand why carriers would want this, and it's putting terms in the agreement that say this truck can only be operated for us. You can't take it and operate it for yourself. You can't take it and operate it for another motor carrier. And that's where I tend to see carriers get themselves in trouble, particularly in the independent contractor situation, because at that point they are beholden to you. And so they can't, it's not their truck. They can't take it and operate elsewhere. And so, there are ways to address that in a way that still kind of minimizes your concern as the carrier. Of course, you're concerned that if they take it elsewhere and operate it somewhere else, maybe we have some liability if they get involved in an accident over there, or maybe they go and damage the truck over there and insurance doesn't cover it and that type of stuff. But there are ways to minimize that. And we would see it commonly. Carriers would build in protections that would say, hey, you can use it under your own authority, owner operator, or you can operate it for another motor carrier. But there are certain things you have to do to be able to do that from a regulatory standpoint. And what we found is a lot of drivers, owner operators, and their interest groups read that language and just throw their hands up and say, well, practically we can't do that. You can do that. You just have to jump through some hoops. Obviously, you can't be, if I've got ABC Trucking's placards on the side of my truck, and then I want to go run that for XYZ Trucking, obviously I have to cover up ABC Trucking's placards and put on XYZ's placards. That's basic trucking 101. And so to say that is an impediment to me being able to do that is just ridiculous. It should be expected that you're going to have to do stuff like that, obviously. So,
Yeah.
Okay, so we kind of hit on independent contractor classification. Maybe you can get us a kind of a handle on where things stand from like a federal standpoint. I know there's been a lot of talk about the Department of Labor and kind of their policy on that as it pertains to trucking.
Yeah, agreeing. Again, change in administration is going to change things. So, just recently, the Trump administration, there's a number of lawsuits, but one in the Fifth Circuit. Trump administration has asked, the court to postpone some oral argument, and really that lawsuit is challenging, Joe Biden's, we'll call it his Department of Labor independent contractor rules. So, kind of the way all this has gone is Trump first term revised the Department of Labor misclassification rules. And again, from a high level, misclassification can happen in a number of contexts. Brandon, you had mentioned it. It could be workers' comp, could be state unemployment, could be state wage and hour, federal wage and hour. So there's different contexts within which an individual could be considered misclassified as an independent contractor. And that's just to say, hey, they're really an employee. And there's a bunch of tests in these different contexts. California's got their
probably most
ABC
famous.
test. You got your ABC test in California, and for federal like overtime, let's say there's overtime claims, the Department of Labor rules are generally the economic realities test. Now, Trump 1.0 in his first term revised the Department of Labor's economic realities test, made it a 5-factor test, and focused on especially whether or not the contractor had control over the duties, what they did for work, and their earnings. And those were kind of the focus of those 5 factors in the economic realities test. And Biden last year, the Biden administration and the Department of Labor changed it back to a 6-factor test. And they call it the totality of circumstances. So it's pretty much whatever the judge thinks is what I think. So the Biden administration changed it, kind of changed it back, and now the Trump administration is going to kind of probably reevaluate that. All that to say is who knows, where it's going to go in terms of that. And again, that's limited.
It's just a roller coaster ride for IC fleets.
But this again, this is limited to wage and hour claims brought under federal law, where a court is going to look at the Department of Labor's test and guidance related to that test. This if you're talking about California, we're not talking about the same thing. So I always tell people with respect to independent contractor misclassification, there is no silver bullet to make sure that you're going to comply with any given test, let alone all of the tests that you could be subject to. Now, we talked about state specific exemptions with respect to workers' comp and unemployment. Those are a little bit more, if you can meet the standards
State
for those,
test.
those are a little bit more clear. But other than that, it's I think you try and mitigate your risk and reduce control and things like that.
There are
But
best
yeah,
practices that,
yeah.
the
Oh, for
fleets
sure.
that don't have trouble with this. A lot of it, as you said, comes down to where you happen to be situated in the country or where you primarily operate. But beyond that, as you said, there are best practices to be aware of when it comes to your contracts, certainly, and also your operations and how you interact with the owner operators. And if you don't know about those best practices, you need to get informed about them. And so that's why talking with somebody like Tyler about those types of issues is important if you are an independent contractor fleet, because all it takes is one of those cases to spring up, and then all of your drivers all of a sudden get reclassified. Now you owe all kinds of back taxes, or you owe some kind of a big judgment or settlement in a wage and hour case. It's just a huge problem for a lot of fleets.
Yeah, absolutely. And the other thing that I'll plug, and it's, tangentially related to, contractor classification is, I look at a lot of agreements and, the agreement is probably the first place you want to start in terms of, looking at your potential risk and mitigating that risk is compliance with the truth in leasing regulations. I see a lot of independent contractor agreements that are just not compliant. And that doesn't have to be brought on, certainly a class-wide basis. You have a couple contractors filing suit in federal court saying that, hey, our independent contractor agreement isn't compliant with the leasing regs. You're going to have to spend some money defending that for sure.
Yeah.
Is it possible that we're going to see for the industry clarity in the issue of independent contractor classification? Because, I feel for the industry, it seems like every time the political pendulum swings, so does IC classification issues. Is clarity even possible for the industry in the future?
I mean, I don't think so. I mean, again, you're looking at so many different tests in different contexts in different states and federally that, it's a real patchwork. I don't think that there's ever going to be like, hey, if you do X, Y, Z, this is the test, right? This is it.
Yeah.
And I think things will change. I mean, we've seen, even the changes in California over the past number of years, right? How their test has pivoted. And that's just California. And we're seeing it federally based on change of administration. I don't think there's ever going to be, real true clarity on IC classification or consistency going forward.
I don't think we'll ever see it, because presumably the only way to get to that would be some kind of a federal preemption of the issue. But when you mix in things like work comp and unemployment, things that have been historically regulated by the states within their police powers and their that type of stuff, I just don't think it's a suitable topic for federal preemption, but who knows?
Yeah, I agree. I don't think that'll ever happen.
All right.
That's
Well,
positive.
that's uplifting show here, Tyler. All right, we got 10 minutes left. You got 2 items left to talk about. Let's hit on them.
Cool. One thing I wanted to talk about was, fleets taking a look at their transportation agreements, and I say, your customer facing agreements, whether it be with a broker or a shipper. And I see this too often is, fleets just agreeing to whatever agreements put in front of them. I understand, hey, there's a lack of leverage a lot of times now. I especially right now where the market's been, you're not going to be able to push back on agreements necessarily. But at least reading those agreements and understanding what you can be liable for, what your rights are, what the other party's rights are, is really important because I think, and we saw this, I think in 2020 through 2022 was, if you had a truck, you had a lot of leverage. People were begging for capacity. And you actually, and this was, at least the first time in my career that I saw that, motor carriers were able to push back on some of these agreements.
So we need another pandemic.
Well, I don't I don't need another
Please,
thing.
God, no.
No, but at some point, the pendulum will swing back to some degree, and where capacity is going to be in higher demand. And if you've got some trucks, hey, you do have some leverage. You do have some leverage. And a few of the things, when you're looking at your customer contracts that you want to either try and focus on. Again, you're not going to probably redline a whole agreement or hire an attorney, spend a few $1,000s to redline an agreement necessarily. But, probably top things, if you're a fleet and you're looking at your customer agreements, number one, limitation of liability for cargo loss. Look at that. The Carmack Amendment 49 USC 14706 allows motor carriers to limit their liability for cargo loss and damage. You can do that. Try and do that. Don't agree to unlimited cargo liability, especially in excess of your cargo insurance. Yeah. And try and make sure that your cargo insurance limits are going to match whatever liability you have for a given shipment.
Yeah,
and this
otherwise
is a big
you're going to
thing.
be on the hook potentially.
Yeah. And I think a lot of people, what are you shipping? What are you transporting? What are you carrying? Right. And knowing the value of it is really important towards limiting your liability. If you're hauling a load of electronics and you have, unlimited cargo liability, and I've seen it, so, an entire truckload of cell phones get stolen and outside of Miami, Florida, who would have thought? And you've got 100,000 in cargo coverage, you're on the hook for that other 900,000. And
it's safe to say that when you're looking at contracts like this, Tyler, there's provisions that are what you would call battleground provisions, and then provisions that are kind of like whatever happens with this provision is fine. What you're mentioning here with limiting liability, that's one of those battleground provisions that you should expect to fight on, and it's worth the fight probably. Is that correct?
Absolutely. Yeah, absolutely. And again, just because you think you don't have the leverage doesn't mean you shouldn't try to push back on some of these things. Unlimited liability, that's not even really standard. I mean, if you're maintaining a cargo liability, policy of 100, try and limit your liability to 100. And that's why you're paying for that policy. And if they want something higher, okay, well, go out and get coverage and understand the value of the goods, because I find, and I do represent, some manufacturers and retailers, and I routinely ask them, I say, hey, what's the average value of your shipments? We got no idea. No idea. Is it 100? Is it 200? Is it more? And understanding what you're hauling and what the value of that is, and what your customers' expectations may be for that, is really important. So if you can, try and limit that liability to what your cargo insurance is carrying. And if they want more, up your insurance rates or limits a little bit. So I think that's probably one of the most critical ones. Another one, that I think is reasonable to push back on, though can be difficult, is, offset or deduction rights. Whether again, your customer is a shipper or a freight broker, that they have the ability to offset your payment for whatever reason. It could be related to a cargo loss or indemnity or some other reason, that they just have a right to withhold your pay. Or offset it against whatever liability that is. I think you try and push back on that, because that's going to affect your cash flow. It could be withheld for, maybe not legitimate reasons, or at least not legitimate reasons in your mind. Let's take a, standard. Hey, I had there was a cargo loss, but let's say it was caused by something, that was completely out of your control and is an exception under Carmack. Tornado came and destroyed the whole shipment. I'm just using a extreme example. Well, if they're going to withhold your pay because a tornado destroyed the shipment, well, that's not legitimate. You're not liable for that, pursuant to the Carmack Amendment, and your pay shouldn't be withheld because of that. So again, offset rights to payment is one to try and push back on or limit to the extent you can. Another one that I see a lot, and I think this is more just being aware, instead of necessarily pushing back, are insurance obligations. So when you look through your customer agreements and you're required to maintain XYZ insurance coverages, I see pretty frequently carriers agreeing to maintain coverages that they don't maintain or limits that they don't maintain.
Like what kind of coverages?
Well, let's say, I see it, hey, you motor carrier required to maintain $5 million in excess liability coverage.
Yeah.
And we know that they don't maintain. Now,
Mhm.
I think carriers should maintain at least that in excess liability coverage with the verdicts that we've been seeing, and they don't have that coverage, but they're still agreeing in the agreement to say, yeah, I've got that coverage.
Yeah.
Well, guess what? You're in immediate breach of the agreement. And I think it's a pretty simple thing to push back on and say, hey, look, I don't maintain that coverage, or revise it and say, hey, you want me to maintain 5,000 or 500,000 in cargo liability coverage. I only maintain 250.
Mhm.
Well, just revise it. That's okay to revise it and say, hey, this is what I maintain, because you want to sign that agreement. You're in immediate breach of the agreement because you're not maintaining the insurance coverages that you're agreeing to.
Yeah. All right. We've only got 5 minutes left. What's your last item on your list of top 5 legal issues to watch out for?
I think in this, I feel like it's discussed to death are, nuclear verdicts related to highway accidents. My only comment on that is for fleets to consider their corporate structure towards protecting their assets. Now we've had some tort reform in a number of states. Florida, Texas, Indiana finally passed the seatbelt law, kind of helping with evidentiary concerns there. I know Iowa, and there's been a number of other states where we've had some successes in tort reform with respect to highway accidents. But look, these extreme jury verdicts aren't going away anytime soon, and you want to take a look at your corporate structure to ensure that you're protecting your assets, both personally, as an owner of a trucking company, and other affiliated companies that you may have, or assets that you may have. For example, if you own real estate and it's owned by the same entity that has the motor carrier operating authority, well, guess what happens if there's a judgment lien? They can take that real estate, right? And just taking a look at that, and even your rolling stock and different assets that you may have. Let's say you've got affiliated, you do some freight brokering, you've got freight brokerage authority, getting that into a separate entity, and just taking a look at your corporate structure to try and avoid some of these verdicts that aren't really going away anytime soon.
Yeah, they definitely aren't. That the perception from a jury now that someone was injured severely or killed, someone has to pay. That perception is there and it's not going away. The answer for me and Brandon typically is more compliance, more safety, cover yourself in that respect. Others would say more insurance. So it's nice to hear corporate structure is something to look at to help you as a company.
Probably a mixture of all three.
I'd say all three. Very important.
All right, guys. Well, Tyler, we appreciate you joining us today. Like I said, we're looking forward to working with you. If anybody's got any questions or wants help with any of these topics, where can they reach out to you?
Well, thanks for having me on, guys. And you can find me at Biddle at childerslawpllc.com. I think you can find me on the website. You can Google Childers Law, and you'll probably find us there.
And on LinkedIn. If you're on LinkedIn, follow.
LinkedIn, I'm on LinkedIn.
Connect with Tyler, and we'll get you squared away. But anyway, thanks for everybody for tuning in. Appreciate you being here. Like I said early on, best way to keep up to date with future shows and everything we got going on is through our newsletter, trucksafe.com/subscribe, or follow us on our various social media pages. We're pretty active on all of them and constantly pushing out DOT compliance related content. So hope to see you next time. Thanks, everybody. Later.